Good evening. This is Rahul Reddy live from Houston, Texas. Every Tuesday, we do bring in immigration updates. Emily, what do we have today?
Today, we want to give the latest updates on the $100,000 filing fee for H-1B petitions as a result of the presidential proclamation from last month. What do we know as of this moment? Anything new? And then we'll talk about the wage-based H-1B lottery regulation. That's just a proposal for now. What it means for people who are going to be filing in the lottery, who might benefit from it, who might not benefit from it, and what the next steps are for that. And we'll go over the naturalization process for people who receive an employment-based green card, things to be aware of and what that process looks like. And lastly, preparing for I-485 adjustment of status interviews as we are continuing to see those for employment-based applicants, what to prepare in order to have a smooth interview.
Emily, as for the $100,000, there is a utter confusion initially, and then later on, there was some clarity, but there is some still a gray area. And I will tell you what is clear, black and white, and I will tell you what I believe is a gray area, and I want you to see if there is any new development from it. So, Emily, anybody who is coming from outside the country and you are applying the H-1B for the first time, whether it's a nonprofit organization or for a lottery system, and they are coming outside the country, that H-1B fees of $100,000 is applicable at this point of time. You first need to pay the $100,000 and file the H-1B afterwards. So that's, however, that $100,000 is not applicable if people are changing the status from F1 to H1, if they're filing the H1B extension, if they're filing the H1B transfer, if they're filing the H1B amendment at this point of time, that fees is not applicable. Now, we yet don't know at this, the gray area part is that if a person has applied the H-1B extension after September 21st, and they are going to stamping now, that means the H-1B must have been filed after September 21st. And if they are going to go for stamping, we don't know if that $100,000 is applicable. If somebody was in outside the country and they had H-1B before, and now they are trying to come back into United States on H-1B, even though they don't go through the lottery system. If they apply the H-1B, we don't know at this point of time whether that $100,000 is applicable. I know that you did contact the USCIS that to give more clarity on this gray area. Did you get any response from the USCIS, and what did you ask the questions, Emily?
I did get a response. It's an unhelpful response, but they did acknowledge the questions raised and that they are actually going to be publishing further guidance in the coming days. That's all they said. This was last Thursday. So we're now the following Tuesday. So apparently it's not quite yet the coming days and it's still coming. But I gave them a specific list of common situations that we see from our employers, from our H-1B beneficiaries, and ask them to confirm that the $100,000 fee does not apply to those specific individuals. So the examples that you mentioned that are currently a gray area, I specifically pointed those out. And so hopefully that will be included in the guidance that is coming soon. We also have litigation that was filed on Friday of last week. Lots of different organizations worked together to file a lawsuit arguing that this $100,000 fee is not within the president's power. Only fees for immigration benefits can only be done by Congress, and the president only has the power to block entry. He does not have the power to levy fees. And so those are all the arguments that are made in this lawsuit. So hopefully we will see some sort of injunction or temporary restraining order while the court actually gets to the merits of the case.
Emily, on the wage-based H-1B lottery right now, are we clear right now? Is it gone through, or what is where the regulations stand at this point of time? And assuming the proposed regulations will be implemented, can you give us the highlights of how it's going to work out for the people who are going to apply for the H-1B lottery?
Yeah, it's still only in the proposal stage, so no final decisions. This is not in effect yet. It's something that could be in effect for the upcoming lottery that will happen in March 2026. But before that can happen, the government has to review all of the comments that it receives in response to the proposed regulation, come up with a final regulation, explain its rationale as to why it decided to act one way or another in response to these comments. And then that final regulation has to be given to the Office of Management Budget, OMB, to give their final clearance. Then the final regulation gets published and it will typically have a future effective start date, 30, 45 to 60 days. So we still have a long way to go with less than 6 months for them to complete this process. There's a chance that it might not actually get done in time for next March. There's a chance there's going to be litigation on it. So still up in the air as to whether it will be there in place and effective for March 2026 lottery. If it is, and if it looks like the proposed regulation, what it boils down to is if your salary offer equates to a level 4 or higher prevailing wage in your work location, you get 4 chances in the lottery. If your salary offer equates to level 3, it's 3 chances. If it's level 2, 2 chances. If it's level 1, 1 chance. That means that level 1 wage offers are going to have a much lower chance of being selected in the lottery. They're not blocked out completely, but based on USCIS's data, it looks like there would be 10,000 fewer people selected that have a level 1 wage compared to last year. Now, that doesn't take into effect the very high possibility that companies are going to increase their wage offers to get to level 2 if they were previously doing level 1. So a lot of people that would only get one shot in the lottery may now get 2 chances instead of just that one. So that's going to skew how it's going to actually come out. But that's kind of the goal. They want more level 4 wage people to be selected and fewer level 1 wage people to be selected.
With regards to the title, we said there are some winners in this particular wage-based lottery system. Who are the people who maybe benefited in this? Especially if you're working in a small, very remote location, very small location, which is not a metropolitan area, you may have a higher chance of getting into the lottery because the wages probably you may be bumped up in the higher level wages. That means that those people who are working in San Francisco or Manhattan, New York area, as compared to somebody working in a remote area in Oklahoma, a city called Tulsa kind of place, then you have a higher chance because prevailing wage there would probably be lower than a San Francisco or in the New York area. So that definitely will be beneficial because the level 1 wage in San Francisco area may be level 3 wage in Tulsa. So that gives a lot more advantage for the rural area people, though. The other people definitely are high wage earners will have an advantage in the new lottery based system at this point of time as compared to the low wage earners. So they will have more advantage. Now, overall, if you club up this $100,000 and this wage-based H-1B lottery, are there still some winners? Yes, I think so. There are some winners. Definitely, the winners are the student visa people, the F1 visa people. If they want to change the status into H-1B, they are not subject to the $100,000 fees. And at the same time, previously they were going through the lottery system. They are going to go through the lottery system again here. Now, however, we don't know at this point of time if the $100,000 will be implemented. Will there be enough applicants to fill the 65,000 plus 20,000 of H-1B? Because there will be less competition for the people who are coming from outside the country. A good number of the H-1Bs are expected to come from outside the country. It's been historically that the people who are outside the country were getting the H-1B. Since the $100,000 is not applicable for the student visa people, it will be an advantage for the student visa people to get through the H-1B lottery. Also, The people who are on L1 visa want to convert into H-1B, for H-4 visa want to convert into H-1B, or any other non-immigrant visas where the conversion into H-1B is allowed, they will be at a greater advantage in getting the H-1B visa lottery this time. If the things stand as it is, including the wage-based, or even if the $100,000, both of them combined together, there are some advantages for the people who are in United States. Any other things, Emily?
Yeah, I think, it's important to point out the types of companies that are going to be disadvantaged by both of these rules combined. Certainly, startup companies that may not have the budget to be able to offer those higher wage level salaries. They tend to be more innovative, cutting edge, bringing us the new technology and the new products. Now they may not be able to get the workers they need in the US. So we could lose out on technology in that situation. And also small businesses do use the H-1B. I know everyone points out the huge numbers of the big companies that are filing, but there are tons of small businesses that do file one or two H-1Bs every year because they're having difficulty filling their positions and they need those workers too. But again, as a small business, they're not able to offer those higher salaries. They're not going to be able to pay this $100,000 fee. So they will also lose out in the lottery and getting that talent that they need.
Going to the
Moving on to naturalization. So someone gets their employment-based green card, they stay a permanent resident for 5 years, they don't do any trips outside the country for more than 6 months. Now they're eligible for the naturalization process and filing the N-400. What things do they need to be aware of? What does that process look like? Any concerns? Should people not be filing right now, given the Trump administration?
One thing is that definitely, as Emily has pointed out, if you have not made any trips more than 180 days outside the country, is one thing that I want everybody to. So if you have any traffic tickets which are under $500, and it's not an issue at all for you to get the citizenship, though. Uh, you can apply online this N-400 form, and you can apply up to 90 days, not 91 days. I don't know how to calculate the numbers properly. I would say that 80 days is a safer period of time that you can apply the citizenship in advance. That means before the 5 year mark itself, 80 days before, you can apply online, though. Now, this process of N-400, even though people are getting confused, there is a lot of pressure that are they doing the neighborhood checks? Is it good to do with? Is it good to have a naturalization file from a blue state versus a red state? I don't think so. There is any advantage to go with a blue state instead of red state. Are they doing the neighborhood check? Especially the people of our audiences, Reddy Neumann Brown YouTube audiences, don't have to worry very much, though. The neighborhood checks mostly are for those people who are, completely dependent on the government. They have used up any of the government medicals. They have used up some of the government resources, and they have not been productive at all. Though they are the people that need to be worried. Now, it doesn't mean that the housewives or house husbands will be affected by this. No, that's not true. Even they are eligible for it, and if they have any criminal remarks or any complaints on them, that's different. But overall, 99% of the people who are listening to these things should not have any problem. It's a very fairly simple application, not a big deal at all. A lot of clients consult me and ask me, "Hey, Rahul, can I want to file with this?" It's simple, put all the marks together, you'll be fine. It's so simple. But if ever you want to, we normally tell them, hey, you can always consult once you fill out the N-400 form, and then we can go over the things to see if there is anything that need to be done. So it's fairly simple. Now, would I say the same thing that you file a 485 application or green card application on the employment base? Definitely not. I would not suggest. But when it comes to the citizenship, it's fairly simple, though. No criminal records, except if you have any traffic tickets for less than $500. And if you have not traveled outside the country for more than 180 days on a single stretch, it's not like you go 2 months each year and it's crossed 180. That's perfectly all right. Nothing wrong with it. On a single stretch, it cannot cross 180 days. Then you are fine to do it. Make
One
sure.
of the Common
Uh,
questions I
Sorry, go ahead.
get, I've had, I mean, since I started practicing, I remember being told or hearing from people that if they get an employment-based green card, they have to stay with that company that sponsored the green card for 6 months before they can leave. Otherwise, their citizenship can be denied. I have been told that old wives' tale, I don't know, countless times in 20 years of practice. Have you ever seen anyone's citizenship denied because they left the company within 6 months after getting the green card?
Absolutely not. Absolutely. I've never seen people who have left the job within 6 months after getting the green card, and they did not had any problem whatsoever at all for them to get the citizenship. Let's say you got a green card with the ABC Consulting Inc., and after 10 days or 15 days, you decided to leave the company. Absolutely not a problem for you to get the citizenship. Never had any problem at all. I don't know where they come up with that. All they do ask, Emily, is they are going to ask the 5 years employment history in the citizenship application. And that is why the lawyers are not confused. Oh, they are asking the employment history. They're also asking your criminal history. They're also asking a lot of different things, though. Have you ever been deported? So, definitely, just because they're asking the information, you're providing the information, doesn't mean that they're going to deny the application based on that. Definitely, if you're going to work for a marijuana selling business, and you are working there, that may definitely be a problem for you to get the citizenship. If you are unemployed, absolutely not a problem for you to get the citizenship. If you are left the job within 6 months after you got the green card, absolutely, absolutely not a problem for you to get the citizenship. You don't have to worry about it. One thing that I want people to notice that every trip you make outside the country, you need to mention that in the citizenship application. The day you left the country, the day you came back into the country. I'm a bit worried about the people who live in the Detroit area where they travel very frequently to the other side, Windsor side of Canada, and they come back. I want you to make a note of every trip that you make outside the country. In the N400, you need to provide all those trips because they want to know how many days you are present outside the country. You're supposed to be present at least for more than 2.5 years on an aggregate, an average in the United States. So you need to provide that information. So make a note of that one. But other than that, there is nothing that you have to make a note. I mean, I don't think so that you will forget your date of birth. I don't think so you'll forget your kid's name. And if you do, then you have to see somebody else, not us. Um, but the only thing that I feel is that you have to keep a note of the people who have been traveling, and every travel that you do, you need to keep a note of it.
Yeah, and note that people who are non-immigrants are used to going to that CBP website and looking up your travel history to get all of the dates of your trips. That doesn't work once you become a green card holder. So you have to keep track of those dates yourself. There's no way to get that information from the government.
With regards to the civic exam, they want to make it tougher, though. Do you think, Emily, our clients will be affected in any way?
No, I mean, all of our clients have master's degrees. I think if they can get a master's degree, they can pass the citizenship test.
It's definitely not targeted for the employment based, anti-employment based immigration people, guys. So this citizenship test, if they make it very tougher, though, I am sure you're going to crack it. No doubt you're going to crack it, though. My mom cracked it very easily. My mom will crack even now, right now, the citizenship very easily. So I think so you can crack it very easily too. I have no doubts. If they make it very tougher, it's not going to be harder for you guys then. Now, it may be a little bit tougher for the people if you are sponsoring for your parents and your parents are applying for the citizenship. It may become a little bit tougher for them, especially if they're not very proficient in English. But for those people who come in here on H-1B, H-4, I have absolutely no doubt everybody is going to crack it. Even if they make it tougher, we are going to crack it. No problem with it.
All right, last topic to discuss is I-485 interviews for employment-based cases. We are still seeing those. They are still happening during the shutdown. I did get one a notice this week for a new interview coming up for one of my clients. So it's definitely continuing. What do people need to do to prepare for the interview? Is it something that they need to be, very worried about? Do you see denials after the interview?
One, we want to make sure that you cannot be unemployed in the period of the adjustment of status. I'm speaking of the main applicant, though. If ever you are unemployed, you should contact an immigration lawyer immediately. There are self-employment is allowed because you might have already have an EAD. So the 60-day grace period is not there. People also ask me question that if is there a chance that if you're unemployed, they may deny the 483 application? Yes, there is a chance they may deny the 483 application if you're unemployed. It's better that you contact immigration lawyer before the unemployment starts or immediately when the unemployment starts. Don't, some of the people will, oh, I got an interview right now. I have an EAD. I don't have to work. I'm going for the interview. No, they're going to deny your 483 application. The whole basis for which they're giving you the green card is because you have an employment offer and you have an employment. So if there's an unemployment, that means that they may think that you may not have an employment offer. And if you don't want to work, they may say, hey, if you don't want to work, why would we give the green card? So that is the number one criteria that I would strongly recommend. Of course, I don't have to tell you that the employment has to be in the similar field for which under which you are being given the your I-140 has been filed. Um, Questions asked is, oh, my priority date is not current. Why are they asking me for interview? They can ask for the interview. They will ask for the interview. I mean, there is about 20% of the time they will ask for the interview, though. So nothing wrong in them asking for the interview, even though your priority date is not current. So they will call you for the interview.
All right. And I would just say make sure you have a copy of your I-485 application that was filed so you can review all of the information in there, make sure it's accurate. The interview itself, a lot of it is going through those questions. Sometimes the officers read through the whole application word for word, re-asking you every single question. Other officers skip around a little bit and just ask some of the questions. So make sure you are aware of all of the questions that are in that form and how they were answered and make sure that they were accurate. If there was anything that was inaccurate in the application, you should discuss with an attorney of when and how to correct that during the interview process, and then just prepare for what other types of questions like they might have for the employment-based applicant. How did you get the job? Who interviewed you? What's your job duties? What kind of things do you do? What does your company do? Should be able to provide just basic information about your job offer, the work that you're doing. None of these are difficult questions. Just be aware of what types of questions they might ask so you don't get caught off guard.
So if they will ask for the employment history for the past 5 years, so if you are working for a different company than the company that filed an I-140, you need to take the I-485J supplement from the new company. They will. I want you to take the employment records, the W-2s, the income tax returns from the past 5 years. Also, I want you to write down from the time you entered into United States, what are the companies that you work and who are the end clients every time. I want you to write it down. I don't want you to give it to them. I want you to write it down and keep it with you just in case, because in the span of 15, 20 years, you might have changed 5, 6 different employers or even more, and you may have changed end clients, maybe 10, 15. You might not remember the dates and all those things because they do have your H-1B application. They do have your I-140 application. They do have your employment history there. So it's better that you do have it in front of you when you go and speak. Also, it's better to have a mock interview done by an immigration lawyer. And if there is any slight things where you or the lawyer thinks so that it may require a little bit more assistance, I strongly request that you take an immigration lawyer with you. Can you take an immigration lawyer with you to the immigration interview? Absolutely, you can. Anything else, Emily, before we go to
Nope,
questions?
we can go to questions. I have one from Krishna. He said, over the weekend, I read one of the tweets from Stephen Brown in our office talking about cases of people being barred or deported when coming into the US on advance parole. Do we have more details about these? So, number one, he did not, as far as I'm aware, I know what tweet you're talking about. He did not make that statement. That was a statement by another attorney that claimed that someone entering on AP was detained. Now, he questioned, what do you mean by detained? Are you talking about were they sent to secondary inspection? Because that's absolutely normal. So I'm not aware of anyone who was blocked entry, barred entry, returned, deported, nothing like that. We still, as far as I know, do not have confirmation of what actually happened in this supposed situation. So I'm a bit skeptical about that. But from our side, we never see people having difficulty entering on advanced parole based on a pending 485. That's probably one of the safest ways to travel in the current environment.
We're not very good advocates of traveling, as you already may know about us. But as far as advance parole is concerned, absolutely. If you have an advance parole valid, your 485 is pending, no problem for you at all, whatsoever at all for you. Yes, some of the officers don't have an authority to let the advance parole people in. So there will be an armed guard that will come and say, sir, this guy will escort you to the soft secondary, and then you have to go there. Once you go there, it takes about 10-15 minutes for them to process and get you out. That's just normal in some of the airports. Some of the offices may not have that advanced parole thing. They do have for the visas, but not for the advanced parole. But otherwise, had no issues at all in advanced parole travel.
Ritesh says, I'm in Canada. My priority date is current, and another employer is saying he can file the 485 while I'm outside the US. Is it possible? Just want to confirm, and how? No, that's not possible. Number one, you can only file the 485 with the company that sponsored you for your labor certification or I-140. If you're looking at another employer to file the 485, that is not an option. Number two, you cannot file a 485 when you are physically outside the US. You must be physically present to file a 485 and qualify for adjustment of status. To proceed with the green card while you're outside the US, you need to file an I-824 if your I-140 indicated you were going to adjust status, so that the whole application can be sent to the National Visa Center and then on to the consulate. So you consular process, do an interview at the consulate and get the green card that way, but still it has to be through the employer that sponsored your labor certification or I-140.
Are there any dress code requirements for interview? Just curiosity. This is such in code for the 485 interview. We normally recommend formal Western dress, though. Do not go in Indian dress. Formal Western dress is what we recommend very strongly. There is nothing like you have to wear a coat, tie, shoes, and you must be well dressed. Definitely, there is no code, but we strongly recommend you do, because it shows that you are respecting the officer. Shows that you're respecting the USCIS. It also shows you're respecting the United States when you go in there. I strongly recommend that you do go very formal and in Western dress, not in traditional dresses, please.
Vijay Kumar says, I'm on H-1B from 2013, have a priority date January 2015. When can we expect the filing date to move beyond December 2014? Well, as we always say, we always predict these wrong, so take this with a grain of salt. We have some data from a few months ago that indicated that there are about 48,000 I-485s already pending for people in EB2 or EB3 that have a priority date before January 2015. How long does it take to get through 48,000 I-485s? If they're all from India, that could be about 8 years. This is somewhat old data. We don't know how many they approved for the remainder of the previous fiscal year that just ended, and we don't know how many are still pending. We don't know how many of those are people that have more than one 485. So it's very hard to predict that, but it's going to still be a while.
Will moral character, is it going to be ground for revocation for the employment-based immigration? Exactly, we don't know what the moral character means. Definitely, if there is any criminal records, that may be a cause for denial for the 485 application, but it depends on what kind of things, though. As of now, there are certain things that we know we have never got any denial. For example, I don't want to give all the examples where the denial did not come in, where people say, oh, Rahul is encouraging to people to do that thing. Absolutely not. But I would say that for the domestic violence case, definitely you can expect a 485 denial. People will ask, oh, case is dismissed. But if you take some pre-trial thing and then let's say probation and the case is dismissed, it it may still end up in a denial of the 485 application. It can happen. So definitely, if you have anything other than speeding ticket, we strongly recommend to contact the immigration lawyer. Let's say if somebody has a DUI, let's say somebody has a domestic violence, or if somebody has shoplifting, we strongly recommend you contact an immigration lawyer. You contact the criminal lawyer. That's number one step that you will definitely do, but you need to contact a immigration lawyer to make sure you understand where are the hurdles, where are the problems that things may occur. We don't want you to proceed by without consulting an immigration lawyer if you have it. Now, if it's just a speeding ticket and you already took care of it can be two things. You can pay what they asked you, or you can challenge it in the court and then get it resolved. Some people hire a lawyer, go there. If the officer doesn't show up, the case will be dismissed, which is fine. Either way, you pay or you get cases dismissed. Either way, it's fine. But if you just neglect it and you don't do anything. You got the traffic ticket. I'm going to throw this one out, and you don't care. Then you will get an arrest warrant. That may be a problem for you at a later date.
Lorenzo says, I'm on an F1 visa and planning to apply for the lottery in 2026. Will I need to pay the $100,000 fee? We don't think so. For anyone filing a change of status from within the US, the fee should not apply because this is an entry ban. And if you're changing status, you're not entering. What we don't know is after you get that H-1B and then you travel, is there any chance that you'll have to pay it? That is unclear yet, and we're waiting for additional guidance.
Emily, what about the shutdown, though, right now? Is there a way out that people who have I have an H-1B which is expiring in October 3rd, 25th. And if the government shut down, what are the aspects that I can do?
Yeah, so the issue for an H-1B is getting the LCA. So if your employer did not get the LCA before the government shut down, you won't be able to get one. Um, There has already been a announcement on the USCIS website. It's a little bit hidden. You have to go to the I-129 form page, but it does say that if you end up filing late because of the government shutdown, because you could not get the LCA, USCIS will take that into effect as part of their nunc pro tunc request to still issue the extension. Now, would I want my client to stay in the US waiting for the shutdown for the government to reopen and overstay their I-94? I think that's a little risky in the current environment with NTAs out there. So I would probably say file a change of status to B2 so that you are covered. You're in a period of authorized stay. And then once the government reopens, your company can file a change of status back to H-1B based on your pending B2. Or if it reopens before your status expired, then just withdraw the B2, you don't need it, and file the H-1B extension as normal.
Yeah, non-protunct is where you're admitting that you are not in legal status. And excuse me, even though one administration will say that we can do it, but as Emily has pointed out, that you may be even issued a deportation order when you file that, oops, my N-94 expired on October 25th. I'm filing this H-1B on November 1st. Please excuse me because it's not my mistake that the government got shut down. Either it's a Democratic mistake or Republican mistake. So please don't punish me for that. That's what the non-protect is for. If there is something that's beyond your control, they should be able to excuse. But I don't know if this administration is going to excuse for the mistake either done by Democrats or Republicans. Doesn't matter. Let's not get into the politics, but it's definitely not your fault. I can guarantee that. But we still don't want you to rely on that. Naveen Kumar
Um,
has this.
I'm sorry.
Go ahead, Emily. You go ahead.
Addie from X says, is there any clarification on H-1B transfers? Will the fee apply? I'm assuming you're talking about the $100,000 fee. We have been filing H-1B transfers after September 22nd, have not had any issues. We've not been paying the $100,000 fee. Everything that we filed in premium processing, we've gotten receipts for so far. Haven't gotten any approvals yet, so I'll just mention that, but that's because we're still within the 15 business day time frame. So it might be next week before we start getting all of those approved. But at this point, I don't see any way that they can claim that an H-1B transfer has to pay this fee because you are not outside the US.
Naveen Kumar is asking how accurate is the travel history dates in the CBP website? Um, s- Most of the times they are, but I have seen like 10 to 15% of the time they are not. And if one of your travel or a couple of your travels are not listed in the travel history, don't panic. It's not going to cause any problem for you. As long as your last entry date is there and up to what time you're allowed to, you're good. Just one travel is missing, couple of travels are missing, or all travels are missing. You don't have to panic. You're absolutely fine.
Fahim says, would this new H-1B law somehow impact the perm process? Could perm be approved faster? It could. I mean, it could be approved faster now. They're just not doing it. Um, the reason for the perm delays has nothing to do with the number of filings they're receiving. It's been very consistent. When they created the perm program in 2005, 20 years ago, they said that they should be able to approve about 100,000 a year in, what did they say, 45 days. They're still getting 100,000 cases a year. There were maybe 2 years where it bumped up over 100,000, but they're not right now. So why is it taking 15 months to get an approval instead of 45 days? There's no reason for it. It's just either incompetence or on purpose, whoever's in charge of that program in the Labor Department. So no, I don't see any plans for them to make it faster related to this H-1B nonsense.
A question from coming from Kannan. Um, the question was that I have an EB-1B I-140 approval, and with company A, I'm right now working with company B. Can I file the 485 application if the company A is going to give the I-485J? That's a document that need to be given. Do I need any additional documents or information from company A? Absolutely. Other than 485J supplement, you don't need any additional documents. Of course, I-140 approval, I don't have to mention about that. And you can file the 485, but you need to have company A cooperate for you that there is a future job there for you in company A, and you can file a 485. We have had so many cases we filed it. Absolutely not a problem.
Deepak says my priority date's in 2014 EB2. Can I downgrade in EB3 and file the adjustment of status? My attorney says it's risky to downgrade in EB3 because the current administration can reopen the old EB2 file and can reject or revoke the EB2. We've done tons of downgrades over the years. When they happened a lot in 2020, everyone was very scared about them, and we said downgrades are fine. We've been doing them all along. It's not a new concept. I think the biggest risk that we find when downgrading from EB2 to EB3 and you have that old priority date is, can your company still establish that they have the ability to pay from your 2014 priority date all the way through 2025 when you're filing this new EB3 downgrade? Now, if you've been working for the company the whole time, that's probably not going to be a problem because they can show that your pay. Obviously, if they are paying you, they have the ability to pay you. But for people who didn't work for the company the whole time and the company maybe had a bad year, maybe during COVID, their tax returns are down, that's where the risk could come in that the EB3 could fail. I didn't really see any of those in the October 2020 filings. So we definitely did a lot of them. Really didn't see a lot of negative outcomes from it. So there would have to be a very specific reason why they're thinking there's a risk there from the EB2 filing.
Emily, is that did you answer the Deepak's question or somebody else's question? That
That was Deepak. Yep.
Okay, sounds good. Imtiaz is asking that question. I've been on H-1B for a long period of time in United States from 2008 to 2018. Then I left to Canada. Now I'm coming back on TN visa, and the officer let me in, but they're telling me that I'm circumventing the system. I don't know what they meant by that. Definitely, it is worrying me. Um, if you're coming by flight, they treat you differently than compared to when you're coming the land border. So I definitely recommend people who are coming on TN visa to avoid the land border. That's one thing. Just because the person makes a statement, you don't have to take it into heart, and you just, God has given you 2 years. In this particular case, please let it hear from here and let it go from there. Just ignore it. You came on a TN visa, you have a job. That is more important. The officers, some of these CBP officers are very, very nasty, and they want to all bad things upon the people who are genuinely doing nice job, paying the nice taxes. They're just jealous that you are having a very better job than him. That's all I will take it.
Anup says, I have a previous H-1B petition, but now I am on an H-4. My employer wants to file an H-1B. Will the $100,000 fee be applicable to me? Assuming your employer is going to file this as a change of status from H-4 to H-1 and you remain in the US, no, it's not applicable to you, even though you're filing after September 21st. What we don't know is if you get that approved and then later you need to travel outside the US in order to come back, are they going to ask you to pay this $100,000 fee? That is what is unclear at this point. But the filing and approval, because it's a change of status, you're not entering the US, you're not subject to that fee.
Sunil is asking this question. Are the interviews waived for the 485 application for the employment based right now? Yes, a majority of them are waived. Only some of them are getting interviewed. I would say at this point of time, 20% of the cases do get interviewed. 20% of them cases do get interviewed, but 80% of them, sorry, 20% of them get interviewed, 80% of them do not get interviewed.
Jay
Krishna,
says,
go ahead. Sorry.
for switching from B2 back to H-1B, have we seen any consular processing approvals if the B2 is still pending? No. We used to see that before the Biden administration made that website update. That was very common. Since that website update, never seen a problem with changing status back to H-1B, even after the website update was archived, still have not had any problems with that.
Special case asking the question, are you sure 100 fees is not applicable when you change the employer when you're going for stamping? Now, there are two things, though. Is the H-1B filed before September 21st? Is the H-1B filed after September 21st? We are absolutely sure that those people who filed the H-1B change of employer before September 21st, this $100,000 is not applicable, because we know some people who already went for stamping after September 21st, but their H-1B was filed before September 21st. No questions asked. They already entered into United States, so we're good with them. We are not sure is if the H-1B has been filed after September 21st and you're going for stamping, we don't know the answer at this point of time. Maybe you will be the person who will do the experiment. When you go for stamping and they ask you for $100,000, we'll say that, yeah, he got stuck there. The special K from X got stuck there, and so everybody else don't go there. That's what we'll tell you, Special K. But we will see if anybody anybody information that we get it, we'll pass it out to you. But at this point of time, the after you file after September 21st, we are not sure.
Vish says my LCA was approved on September 25th, but my company's attorney says they cannot file the H-1B because they can't retrieve the LCA due to the shutdown. Are there any issues to get the LCA during the shutdown? Yeah, if they didn't get it from the system before the shutdown, they cannot access the system to get it, even though it got certified before the shutdown. We can't even log in. Like it just says the site's under construction for anything related to perms or LCAs.
Krishna is asking a very good suggestion. He's saying, once I get the green card, can I can apply for the USCIS and hopefully aid adjudication of the cases faster. Thank you. That's a very nice gesture from you, Krishna. But however, what if you go and become the dark side? Have you not seen the movie Star Wars and people become heroes, become villains? I hope so. You don't become villain for us, though. Just because a person has gone through the process doesn't mean that they can be a friendly, though. I've seen some of the things that people with Indian background, they became more nastier than the normal people. Now, I don't know why. So historically, that it's not proven that the people who have some Indian backgrounds have been very friendly with immigration. No, in fact, the vice president of this country, his wife is an Indian. And when Kamala Harris was a vice president, she didn't do that benefit to the immigrants who are coming on the employment-based visa, the same kind of things what her parents were in. So we haven't seen that. So we don't know if you are going to do benefit to us or you're going to join the dark side of it, though. Hopefully, so you don't.
Uh, Bhagavan says, is there any update this week on the visa integrity fee for the visitor visa? No, still nothing. There's still no way to pay it, still no updates about it on the consulate's websites, still no idea how you get it back after you paid it and complied with your visa. So everything's still up in the air with that right now.
Um, the question from Usha Rani, H4 staying in USA, she's intending to apply for the H-1B lottery in March of 2026. Is the $100,000 applicable? Absolutely not. In fact, it's a good deal for you, Usha, that you don't have competition coming from outside the United States. You have higher chance of selecting in the lottery. If not, there's a very good chance, or there may not be a lottery in the first week at least, because it's first come, first serve. So if they don't get enough applications, even if you're level one, they have to give up that thing because the lottery is only if within that stipulated time, the number of applicants should be. If there are no 100,000, if there are outside people are not coming in, you may be lucky. So it is a good deal for you. However, though, once you get the H-1B, now if you want to go to India and you want to come back, the $100,000 may be applicable. We don't know at this point of time, but we will give more clarifications once we get from the USCIS.
Shanawa says my I-140 was approved back in December 2024, completed the 180 days, and then filed an H-4 EAD in February for the spouse, then got laid off. Wants to know if the H-4 EAD application will be able to continue to be processed or if it will be canceled. It will still process. The I-140 can continue to be used for you to get H-1B extensions with any employer, and it can continue to be used for your spouse to get H-4 EAD and those extensions going forward, even though you're no longer with that company. And that's because the I-140 had already been approved for 180 days.
Question coming from green card citizenship issues that I am if I use the marketplace, which is kind of where the government is recommending marketplace health insurance, is that going to be any problem for me to get the citizenship? Absolutely not. It will not be a problem at all. Now, there are some people who don't have health insurance. They still get the citizenship, though. So, no, I'm not recommending you that, but I'm just telling that, no, you're good. Not a problem.
Shaw says if I have a previous H-1B that expired but had 2 years of unused time, can you use that for a new cap exempt job without paying the $100,000 fee? If you are in the US in some other status and filing a change of status, yes, you can do that without paying the fee. What we don't know is if you are outside the US and filing for consular processing after September 21st, 2025, we don't know whether you will be subject to this fee or not, because we don't know what they meant by new petition. I think they meant going through the lottery. And so it shouldn't apply to you, but that is still one of the gray areas that we've asked for guidance on.
Very good question. Coming from Trapped Indian, very good title that he got. He's from X, is asking the question. Is there issue with automatic revalidation process after the proclamation? Now, there are two ways that we separate it here. If your H-1B has been filed before September 21st and you are traveling to Mexico or Canada and you have the valid I-797 with the I-94, you're coming back within 30 days. That's what called automatic revalidation. Even though visa is not stamped, you can go to Mexico and Canada and come back. He already knows that, but I'm just telling the other people, and you can come back. If the H-1B has been filed before September 21st, the $100,000 is not applicable. If the H-1B is being filed after 21st, and you got the approval, you are here, and you got the I-797, and you got the H-1B approval, is the $100,000 applicable if the H-1B is being filed after September 21st? We don't know. If you, trapped Indian, want to be the example of it, if after the September 21st, we recommend you don't, if you travel to Mexico or Canada, we will say that trapped Indian went out to Canada for a nice trip there. When he's coming back, they asked for the $100,000 from the employer. Employer didn't pay it. He got stuck. We will tell you that. If you come very successfully, we will tell you that he came very successfully, then we can tell other people to go. At this point of time, we don't know the answer if the H-1B is being filed after September 21st. That's the main thing. Two things that you need to watch out. Is the H-1B filed before September 21st? Or is it filed after September 21st? If it's filed before September 21st, the $100,000 is not applicable, even if you go for stamping, even if you do automatic revalidation, the $100,000 is not applicable. If the H-1B is filed after September 21st, even though you are in the United States, we yet don't know whether the $100,000 is applicable, so don't travel.
Mohammed says, my wife is on F1, kids are on F2, and recently his employer filed the I-485 for him and his entire family. He wants to know how long does his wife need to maintain her F1 status? I mean, technically, she doesn't. Once that 485 is filed, if she wants to stop going to school, she can remain legally in the US based on the pending I-485. She doesn't need to continue her F1 status, but if she wants to work, she needs to wait until she gets the EAD. She wants to travel, she needs to wait until she gets the advanced parole.
Question that is, it's not a question, the statement that is coming. Agree, some of the CBP officers are indeed nasty. Now, if anybody agrees with Dr. Captain Hadcock, please give us a like so we know that, okay, this came for the comment what he's making, that some of the CBP officers, I wouldn't say all of them, but some of them are really nasty. And there are some officers, especially in the Dallas CBP office, when you go for any corrections of the CBP office, they are very, very nasty. If they are working for our office, so we would just fire them. And believe me, if they are so nasty with the customers, we would fire them. Now, of course, the government doesn't work that way, the same way that private offices work. But yeah, if they are working for private organizations, I cannot imagine any private organization that can keep them as an employees. And maybe that's the reason they end up there, that they cannot work with any private organization. They go end up working with the CBP because they can be have very nasty. I don't know why they get that kind of nasty. They have to haul the things upon them. They have to insult the people. They have to use the bad words to these people. Uh, I don't understand why they get some kind of satisfaction. I don't know what kind of satisfaction they get in that thing. Yeah, they are working for the government, unfortunately. Previously, there are ways that we could contact the CBP officers to dismiss these employees. At one point of time, when I was the ALA director in immigration lawyers director in Houston, there was one officer in the USCIS that was very nasty. We went and complained. We got that guy dismissed. Two times that happened in the Houston office that we did. But with the CBP office, it's very tough. And this administration won't even hear to us.
Nihant says if we're filing for the H-1B under the cap coming up based on the salary, how will they know about our salary? Is it just through the LCA or do they ask for paychecks as supporting evidence? Yeah, that's one of the problems I have with running the lottery based on the salary is there's not going to be any enforcement until after the fact, until 3 years later when it's time to file the extension. Will they then look at your pay statements or W-2s to determine whether you were actually paid that wage? So when the company is submitting the registration, they will specify the salary, the work location, the occupation code, and then they will specify which wage level that falls under. They will run the lottery simply based on that. Now, once you file the petition, the company has to follow through with whatever they put in the registration. If there's any mismatch between what they're putting on the LCA and the I-129 and what they put on the registration, USCIS could deny for that reason. Or if they file it, you get the approval, and then you turn around and join the company's brother's company at a much lower salary, they can connect the dots between those two companies and say that you're using it to game the system, and they can go back and revoke the original H-1B, but that cap number is lost by then. That's the thing that bothers me is we don't enforce anything until after the numbers are wasted.
Why are we talking about the September 21st? Where does the date come from? September 21st is where the $100,000 went into effect, though. So that is where the September 21st comes in. Before September 21st, there was no $100,000 fees. Second,
Sunson says, I'm on L2 working as a professor. If I change my status to H-1B, does it require the $100,000 fee? Again, if it's a change of status, you're inside the US. Generally, our reading is that it does not apply. What we don't know is what happens if you later travel after you got that change of status. And that should be announced in the coming days, whatever that means in terms of USCIS timing.
question, when do you expect a result on the injunction with regards to the 100,000? Soon, though, since it's an injunction, though, it should be soon. We're expecting probably this week or maybe next week is at least we can get some hint that where they're heading at. It may not take a long period of time to grant an injunction, though. We will see that in the next 1 to 2 weeks.
Shah says, is there any update for the physician exemption from this H-1B fee? No, there is no information about exemptions, who qualifies, how to qualify for one, whether they're going to do it for physicians, whether they're going to do it for cap exempt institutions. No news at all on the exemption of from the proclamation.
Deepak is asking do you expect in 2026 the EB2 movement advance for Indian nationals? We do not expect much advance, but gradual advance probably maybe, but not advance that if you have some priority date after 2015, January 2015 or afterwards. Do I expect the priority date to move that? Maybe not in 2026 though.
All right, I think we're out of time for today. Thanks everyone for joining us. As usual, we'll be back next Tuesday, 5 o'clock Central Time to give you the latest updates and answer your questions live.